so excited today. We have Kevin Golembiewski, and I just asked him his name too, and now I'm messing up his pronunciation.
That's all right.
Kevin, he is the Director of Advocacy, Education, and Outreach at Disability Rights Florida. He previously worked as a civil rights attorney at a private firm focusing on disability rights. And then we did joke beforehand because I said what people really care the most about are pets and kids. And so he has two young kids, so it's really nice of him to be here today because I'm sure he's exhausted with a 2-year-old and a 3-month-old, but then he has 2 cats. So Kevin, thank you so much for joining us today to talk about Roger gives you the thumbs up. Thank you so much for joining us today.
Yeah, thanks for having me. I'm excited to talk to everybody. I'm going to focus on just rights, federal rights protections in schools, the workplace, and the community, because I know that people are from different states around the country. Even though I'm from Florida and usually talk to Florida people mainly, don't hold that against me. And I want to focus on federal laws because, of course, every state can provide additional protections for people with disabilities, but the bread and butter protections are all federal, and so they're going to apply. I see there's people from California, Arizona, Indiana. They're going to apply across the board. And I also just want to introduce everybody to the Protection Advocacy Agency system in case folks aren't familiar with it, because our role in that as part of that system is enforcing these federal laws and protecting people's rights. So let me share my screen here. Okay, so there's everybody. Can everybody see that? Okay. So here's the overview, like I mentioned, introduction to the P&A system, federal disability rights laws, and then a focus on community workplace protections as well as school. And for this group, I wanted to focus on post-secondary institutions as opposed to K through 12. Just based on my discussion with Eden, it seemed like post-secondary would be a better focus than the K through 12 sector. Okay, so Disability Rights Florida, where I work, is a federally mandated protection and advocacy agency for the state of Florida. And that means that we are charged under federal law as well as under state law with advocating and protecting the rights of persons with disabilities. We receive federal grants to do so, and we're part of a nationwide system that provides these protection advocacy services. So the protection advocacy system was developed in 1975. It was started after, some of you may be familiar with this, Geraldo Rivera did an expose on Willowbrook Institution in upstate New York and found that was an institution that was housing persons with disabilities, and found that they were abused, neglected, and really segregated from society. And that expose led to Senator Jacob Javits of New York at that time passing legislation and proposing legislation to develop the Protection Advocacy Agency system, because that was not an isolated incident at Willowbrook. Across the country, you had abuse and neglect of people with disabilities in institutionalized settings, as well as just a lack of rights enforcement more broadly. You had millions of students with disabilities who weren't even attending K through 12 school. And what Congress and Senator Javits determined is that you might have federal laws on the books, but they're meaningless without enforcement. And that was the genesis of the Protection and Advocacy Agency. And so now all across the country, every state has a P&A, as they're called. There's Disability Rights Florida, Disability Rights Texas, Disability Rights California, New York, etc. So every state, for the folks that are on this call, you have access to this agency. And the real value of P&As, and some of you might be familiar with legal aid services. Well, there's legal aid services provide free legal services and rights enforcement to low-income individuals. the value of PNAs is we provide free and confidential legal services and support to any individuals with disabilities. There is no income limitation or requirement. And so if you're a person with disability and you feel like your rights have been violated, you can call us or call your state PNA and go through their intake. And if they find that you have a meritorious claim or issue, they can assign an advocate or assign an attorney to assist you individually with your issues. And so here on this slide has a list of some of the services that we provide. We do self-advocacy support. And so one-on-one talking to you about your rights under the various federal laws and identifying individuals you can contact within the organization or entity that's posing you problems to resolve that issue. We investigate allegations of abuse, neglect, or rights violations. And then if we investigate and find a serious problem or that you have been discriminated against, we have attorneys that can provide legal advice and representation. And so on my team at Disability Rights Florida, we handle all claims of employment discrimination, education-based discrimination, community access problems or barriers. And we have 6 or 7 attorneys on our team, as well as advocates who get assigned to the cases to enforce rights violations in those different settings. And every PNA across the country has a similar setup. And so I think PNAs are a really underutilized resource in a lot of communities. And we can make a big difference in enforcing your rights, and we're charged to. We get federal funding to do so. So you should definitely take advantage of us as a service. Okay. And now, to pivot into more of a substantive talk about your rights protections, there's really 2 main statutes that protect the rights of individuals with disabilities in employment, in the community, and school outside of K through 12. And it's the Americans with Disabilities Act, which was passed in 1990. And that so now has been in effect around over 30 years. And then there's Section 504 of the Rehabilitation Act of 1973, which has been around much longer. The ADA has 3 parts to it. The first is Title I, which provides protections in employment. And so any kind of employer that has more than a certain number of employees must comply with the ADA and provide reasonable job accommodations and avoid discrimination against people with disabilities. Title II of the ADA imposes requirements on government services, so state and federal agencies. They cannot discriminate against persons with disabilities under Title II. And then Title III complements Title II by extending protections to all places of public accommodation, which is really just a fancy word for the places that you go in your day-to-day life: movie theaters, grocery stores, theme parks, convenience stores. Those places also cannot discriminate based on disability and must provide reasonable modifications to ensure equal access. Section 504 is consistent with the ADA. Most of its standards and protections are the same as the ADA, except 504 covers entities that receive federal funding. So there's going to be a lot of overlap. And you'll see when I talk about colleges, most colleges are public and run by the state. So they're covered by Title II of the ADA, but they also receive federal funding. So the requirements of Section 504 apply to them. 504, for example, is also a way that private colleges end up having to comply with disability rights requirements, because although private colleges might not receive direct federal funding, the students that attend get federal loans, and that benefits the college. And so Section 504 can extend to private universities. But when I'm going through these categories in more detail, this is kind of just the general framework to remember, and that there is a lot of overlap between these 2 important disability rights laws. Okay, so I'll start with college and post-secondary institutions. So Title II and Title III, as I mentioned, as well as 504 apply to these. And their mandate, Title II, 3, and 504 is their mandate for college and university is that those institutions must make their programs, services, and activities accessible to individuals with disabilities. That language, programs, services, and activities is broad and intentionally so. So it's not just the case that the physical structure of colleges must be accessible and provide for equal access. It's also the classes at colleges and the extracurricular activities and the theater and plays and forms of entertainment. All those things are programs, services, and activities hosted by colleges and universities. And the federal rights laws, they prohibit two types of discrimination. There's intentional discrimination, which is really the classic form of discrimination that people think about, where a college might say, we're not allowing you to attend or granting you admission because you have dyslexia or a movement disorder. That's like the real classic form of discrimination. But these laws are much broader, and they also classify as discrimination a failure to afford an individual with disabilities a reasonable accommodation. By failing to provide a reasonable accommodation, the facility or college is necessarily denying an individual equal access. And the laws state that that's a form of discrimination in and of itself. And so we at Disability Rights Florida, we get a lot of calls from college students, attending community colleges, universities, that say they need an accommodation, mainly in the classroom setting, in order to equally access the class material. And so some examples of accommodations that students request and can request are periodic rest breaks. So maybe sitting down for a 2-hour exam is very difficult because of fatigue associated with the disability. Well, it's a reasonable accommodation to seek to take rest breaks throughout that exam and be able to complete the exam in 4 hours rather than 2, for example. There's a note taker. If someone has difficulty with writing, especially if a professor is rattling off information for 60 minutes straight, a college can afford an individual student a note taker, either a peer or a staff member, as a reasonable accommodation. A student can request a copy of a PowerPoint before the class, assistance navigating campus, or accessing class and the campus with a service animal, which is actually a common issue that we see because service animals, of course, can assist with mobility and balance. And so we've had a couple of students who wanted to have their service animal in the dorm room or wanted to have their service animal in class during an exam, and we help them navigate that issue. Now, in the college setting, though, it's really important to know your rights and know your burden in seeking an accommodation. A lot of times we'll have students that come to us and say, my school or my professor knew I had a disability, but didn't help me at all. And then I ended up failing the class. Well, there's no violation there because the students have the responsibility to request an accommodation. It's their burden in legal terms that they make a specific demand for an accommodation. And so if you are a student with a disability or know a student with disability, the first thing that they should do is registering with Student Accessibility Services. That there's different names of different colleges, but it's basically an office designated to handle ADA requests and assist students with disabilities. And they typically require medical documentation because you really need to show 3 things to get an accommodation in college. That you are a person with a disability, that there's a reasonable accommodation, one that doesn't give you an unfair advantage, but just levels the playing field, and that accommodation is necessary. And so it's your burden to come to the college, provide documentation that you're a person with disability, and articulate a specific accommodation. And that is different than the employment setting, which we'll discuss later on. There's a buzzword that many people hear when it comes to employment that is called the interactive process. And that's where the employer has a duty to engage with you to identify a possible accommodation. And I think some people assume, well, because the ADA requires the interactive process in employment, other settings that's required too, but it's not. In the college and university setting, the burden is really on the individual to make that request for a specific accommodation. Okay, so I'll move to rights in the community. And you're going to see a lot of overlap here, the same language, reasonable modifications, accommodations, to policies and practices, because the ADA really has that reasonableness standard throughout the statute. So I see the community as involving both ADA Title II and Title III, and that's how we look at it in our work, because accessing state agencies and state benefits is just much as part of community integration as is being able to go to the grocery store or go to the movie theater. And our mission as the P&A system is helping people realize their right to self-determination and inclusion in the community. And so barriers to state services or state facilities is just as important as barriers to private businesses within the community. And so under Title II, public entities must make their programs, services, and activities accessible to individuals with disabilities. That's the same language and standard that I discussed in the context of colleges and universities, because it flows under the same law. Colleges are state entities, and so are state Medicaid agencies or state agencies that provide food stamps. And so persons with disabilities are entitled to reasonable modifications in policies, practices, and procedures, provisions of auxiliary aids, and removals of barriers in existing facilities. And again, this language emphasizes that the protections are not limited to physical access. It's broader access so that you can equally benefit from your state or the federal government services. And so an example that we see pretty frequently, I think that drives this home, is if there's a program that the state of Florida has developed to provide rental assistance to individuals. So we got hit with Hurricane Ian, and there were some rental assistance programs and similar during COVID. And to apply for those rental assistance programs, you had to go online and fill out an application. But we had some complaints because the online application wasn't compatible with a screen reading software. So individuals with visual impairments couldn't fill out that application. And so that's an example of, well, there needs to be a modification to ensure that those individuals have equal access to the application process. They don't have some additional right to get the funding, but they should at least have equal access to the application process. And so in those situations, we'll either assign an advocate to work directly with the state agency to allow a paper application, or it's better to make the website completely accessible to both folks with and without visual impairments. Public accommodations. So this is all Title III of the ADA. And public accommodations is very broad. So it's disability discrimination by privately owned, leased, or operated facilities is prohibited. And those types of facilities include stores, restaurants, doctors' offices, theaters, hotels, stadiums. It's a very broad mandate. Really, the only types of entities that are excluded from the ADA's reach in Title III are private membership clubs. So maybe like the Kiwanis, Rotary clubs, things like that. There's sometimes an argument that they don't have to comply with Title III, but otherwise it's a pretty broad scope. And again, you have a similar language under Title III as Title II, where there must be made reasonable modifications in policies, practices, and procedures, provision of auxiliary aids, and removal of barriers in existing facilities. Now, in addition to this reasonable modifications requirement, there's a whole nother set of complicated requirements for the physical structure of places under the ADA. And so there's certain requirements that if a building is built after a certain date, it must be accessible to folks in wheelchairs and have certain number of parking spots, et cetera. But older buildings don't need to be modified. That's more complicated. I think the big takeaway is, though, modifications to policies, practices, and procedures to make sure you get equal access. And so here's some examples that apply both to state facilities and to private businesses. Auxiliary aids to facilitate effective communication. So that means requiring, for example, maybe a sign language interpreter to someone who's deaf of hard of hearing. That is a reasonable accommodation, particularly in the medical setting. We have many cases where folks who are deaf or hard of hearing or have another communication related disability need a sign language interpreter in order to effectively communicate with their medical staff and doctor. And the doctor's offices have an obligation to provide that type of service under the ADA. Access to scooters and other mobility supports can also be a reasonable modification. So here in Florida, we got the Mouse, we got Disney, we got Universal, we got a lot of big amusement parks. And those parks are designed in a way that's sprawling, which makes it inaccessible for people with mobility impairments or movement disorders. And to ensure those individuals have equal access where they can go to the park and attend multiple rides in a day, it might be necessary and reasonable to provide them electric scooters. And so we've had cases sometimes where someone will come and they'll request in advance to use an electric scooter at Disney. And they show up and Disney says they're all gone. They were all already used. And so sometimes we'll make a complaint to Disney to address that type of failure to accommodate. Access with a service animal, again, that same right extends not only in the college setting, but also to accessing private businesses, medical offices, and state facilities. Access with a support person. I know sometimes in hospital facilities or assisted living facilities, for example, there might be restrictions on who can actually enter the premises and attend a visit with someone. Well, if you need a support person, that might be a modification to a policy like that, where the entity says, we will modify that policy, allow you and this other individual to attend as an accommodation to your disability. And then another example, there is a very common example, ramp access is important, or use of an elevator. And so maybe you're not in a wheelchair, but your mobility is limited. Well, and you can't climb up 3 sets of stairs. Well, an elevator or other device that will facilitate your equal access should be provided to in most circumstances. Okay, rights in the workplace. And I was going to spend a little bit more time on this area. Workplace rights all flow really from Title I of the ADA. There's other laws and different states have their own human relations acts, which provide protections in employment, but the ADA is the main source of protection, at least that we assist with. And so that prohibits discrimination in the job application process, hiring, firing, advancement, compensation, training, and all privileges of employment. And so that all privileges of employment language is robust. And you can't really have an employer take an adverse action, period, against a person with a disability because they have a disability. So it even extends beyond firing and termination, those major decisions. It might be you can't receive a demerit or a write-up in your folder solely because you're a person with a disability, for example. The biggest issue that we see and assist with is folks seeking a reasonable accommodation and it being denied by the employer. And so just the same logic applies as in the Title II and Title III context, where if you need a reasonable accommodation to equally perform the job, just like you need a reasonable accommodation to equally access a college class or building, then you're entitled to that if it'll allow you to perform the essential functions of the job. And just as a note, before I get into reasonable accommodations more, we don't enforce Title I at Disability Rights Florida in the PNA system. We'll investigate, advocate, and assist you with it. The real enforcement agency that everybody should be familiar with is the U.S. Equal Employment Opportunity Commission. Because if you feel like you've been discriminated against, you can on your own file a charge with the EEOC, and they'll investigate it and decide whether there has been a rights violation. And that enforcement entity, it's an administrative entity that Congress established to facilitate people being able to raise these claims and file charges on their own without needing to turn to an attorney, because oftentimes it's hard to find an attorney, or the attorney might be too costly. So the EEOC operates in every state across the country, and it's an important tool and important to know about them if you're having issues with employment discrimination. Okay, so essential job functions. This is very important because I think a lot of times a dispute, when someone requests a reasonable accommodation, it will be denied because the employer might say, well, even with that accommodation, you can't perform the essential functions of the job, or basically the accommodation you're seeking would alter the essential functions of the job. And that's not acceptable under the ADA. And so the essential job functions are the basic duties that an employee must be able to perform. And usually the essential job functions, you can identify them by looking at your job requirements. So most HR departments will develop a list of job requirements and duties for each position. And typically what's listed in those that is the essential job functions that you must be able to carry out. An example that drives this home, I think, is during COVID, a lot of people worked remotely for a period of time. And then they came back and they thought, well, I was working remotely, so that should be a reasonable accommodation and not a departure from my essential job functions, even though the job duties might say you need to be in the office to greet customers or in the building to greet customers. In that context, the EEOC, for example, in the case law, I think, are indicating that the employee doesn't have a valid claim there. COVID was extreme circumstances. And if your job duties include greeting customers or interacting with customers, you need to be on site to do that. And so seeking telework would be a deviation from the essential job functions, and it's not an appropriate accommodation. That is something that we're seeing a lot. I think one of the biggest accommodation requests that we see is for telework post-COVID. But I think that example drives home is what is an essential job function and what types of accommodations can you seek in order to navigate those job functions. Okay, so a reasonable accommodation, an accommodation must not only not basically depart from or invalidate essential job function, they also must be reasonable and not pose an undue burden on the company. So accommodations can include adjustments or modifications that enable individuals with disabilities to perform the essential functions of a job. And they really can vary. There is no cookie cutter list of accommodations that you can choose. It's whatever is necessary and reasonable for you just to perform the essential functions of the job. So here's some examples. And actually in preparing for this, and I could send this out to everybody after, but the federal government funds an organization called the Job Accommodation Network. And the Job Accommodation Network is basically a helpline and an information source that will provide individuals information directly who call on the ADA and their rights. And the Job Accommodation Network actually recently put together a long PowerPoint about accommodations and the interactive process for individuals with Parkinson's or movement disorders. And it was really great. Actually, I can try to let me pull that up because I thought that was fantastic. Because they go through all the different types of symptoms and issues that might arise related to Parkinson's and how they can be accommodated. And I pulled a couple of them off that and put them on this. So a rest area, private space when there's fatigue, a job coach, because if your symptoms are changing or the effects of your disability are heightening, you might need a job coach to come in to work with you and help you with navigating those and identify assistive technology that can help you navigate those new effects. And that can be a reasonable accommodation. Let me see if I can, I'm going to try to stop my screen share. Oh, I don't think I can do that. No, that's all right. I'm going to send that out, that slideshow, because I think it's very valuable. But so some of these accommodations, like I said, are particularly, I think, could help your community, specifically assistive technology, a job coach, rest area, private space, reassigning to a vacant position. So maybe your position becomes very difficult because there's a lot of moving around, or you're getting fatigued later in the day and there's a high demand in your job later in the day. Well, if there's an open position that can accommodate your needs, that's a reasonable accommodation. An employer doesn't have to create a position for you, but if there's an open vacant position, that could be an accommodation. Accessible parking, modified work schedules. So one thing that we see is folks that might have fatigue later in the day or have pains at certain times of the day, they might ask to work earlier in the day. So instead of starting at 9, start at 6 and go until 2 p.m., for example. Those are all things that you can discuss with your employers. And here's some more examples that are a little bit more specific. I think those were general categories, but you can also request telework while undergoing medical and psychological treatment. And so maybe telework is a departure from the essential job functions if you're seeking to do it indefinitely. But maybe if you need to go to the doctor's office or receive treatment a few times in a month, and on those days, it wouldn't make sense for you to go into the office or it'd be too taxing for you to do so. Well, you could ask to telework the remainder of the day from home, so you don't have to use your leave time, for example. You can request additional breaks throughout the day due to migraines or headaches or other kind of fatigue symptoms. That can be an accommodation. I think sometimes people will seek to use their Family Medical Leave Act leave, which is unpaid, if they need to take additional breaks or longer gaps in their work time. But you can use an accommodation to obtain that same outcome. I mentioned requesting to begin work early and requesting a transfer to an open position. And that open position could include totally different tasks. You know, it doesn't have to track the exact same job that you have. Okay. So say you've identified an accommodation, it's necessary, and it seems pretty reasonable in that the company is not going to have to totally rearrange an office or your schedule. Well, still, they can deny or decline it if for some reason they say it would work an undue hardship on the operation of the employer's business. And so employers have that protection where if something's extremely costly, or even if an accommodation would disrupt just like their typical interactions with customers in a way that they find fundamental, they can say it's an undue hardship and not provide it. And so, as you can see, there's kind of like this burden shifting process where you might identify an accommodation and the employer might say, well, that's an undue hardship. That's not going to work for us. Let's go back to the drawing board. And that process is contemplated in the ADA, and that's the interactive process that I mentioned earlier. So under Title I, employers have a duty to engage in a back and forth with you. They can't just say, unlike in the college setting where a college could say that specific accommodation you want is not reasonable, we deny it. If you come to an employer with a showing that you're a person with disability and you could do the essential functions of the job with the appropriate accommodation, that employer needs to engage you. And this is probably the most common violation we see. We don't necessarily see frequent violations of denials of accommodations altogether, but we'll see situations where someone requests an accommodation, HR issues a letter a month later that says we're not providing that accommodation, and there's no invitation to engage in a process or recommendation of alternative ideas or accommodations. And that's a violation, because under the ADA, this interactive process is an important procedural requirement to make sure there's this collaboration and that individuals with disabilities can understand, well, what's going to be an undue burden? You can't just deny the accommodation as an employer without explaining what's the burden and then trying to problem solve to identify an alternative way to address the person with disabilities needs without burdening the employer unduly. And so, a best practice is similar to in the college setting. If you're a person who thinks you should have an accommodation, disclose it, go to HR, disclose your disability, request an accommodation, really think about what the essential functions of what your job are, and tailor your accommodation request based on those functions, being careful not to request something that's going to knock out the functions or deviate from them. And then once you do that, it's really HR's duty to engage you and say, okay, well, maybe we need a couple more documents, and explain to you the interactive process and then engage with you on it. And if the interactive process breaks down, you can call a P&A. You can go straight to the EEOC and file a charge, and same if there's just a complete failure to engage in the interactive process. And I think a lot of times people are nervous about doing that, about going to EEOC or going to a P&A and bringing in a third party to assist them with this. But I think it's rare where a company retaliates. And I think oftentimes, at least when the P&A gets involved, the companies will appreciate it because we can bridge any kind of communication breakdowns and make sure that the company really understands the person's disability. So I wouldn't let nervousness about the company's response serve as a barrier to you seeking help if you need the accommodation, because if you lose your job and then after the fact say, well, I was a person with disability and they never accommodated me, it won't matter if you didn't take action on it while you were in that position. And as a final note, I'd be remiss if I didn't mention, because we do work with the Division of Vocational Rehabilitation. That's another resource. And there's vocational rehabilitation services in every state. It's funded by the Rehabilitation Act. And so if you need help with a job coach, or you don't have a job and you need assistance with finding assistive technology or support to pursue a job, you can go to your state vocational rehabilitation agency and they will support you in that, and help connect you to work. And that's another thing that the P&A system helps with. We all have teams in our agencies that's their main function, is to connect people to vocational rehabilitation services. And so that's a complement to our work on behalf of folks under Title I. So some people, they want to fight for their current job and can perform those essential job functions with accommodations. And some people might get to the point where that job's just not going to work. And that's where VR comes in, and they can support you in finding a different position and even getting training and things you might need to change your skill set. And so that's it. And for anybody in Florida, that's our contact information, but you can just look up Protection Advocacy Agency and put your state in on Google, and it'll come right up if you seek to contact your local P&A.
So much, Kevin. So they should put in protection and advocacy, not like disability rights and their state to find it, or how
Yeah,
would you?
that's easier just because I think sometimes when you put disability rights in your state, even if it's disability rights Texas, you might get like disability rights law firms. And so if you do Protection Advocacy Agency, Illinois, Michigan, it'll typically come right up.
And then, was I the only person who was shocked that the ADA has only since 1990? When you said that, I kind of thought,
Oh yeah.
no way.
Yeah, I know. Yeah, and the pictures, I didn't include any of the pictures, but all the pictures, it was President Bush, H.W. Bush signing it. Yeah, so it was only, 33 years ago. And so there's a lot of implementation still going on, and the business community still acclimating to it.
One thing you had also mentioned, and I wondered, that private clubs could be excluded. So then I thought about, like, say, a country club, or a golf club, because that is essentially private, but I thought they might have public events. Would that be something someone would have a problem with if they were like, I'm going to a wedding, but this is like a private, like a yacht club or something? Do they not have to follow the guidelines?
Typically, if they're having public events, yes, that's like a very complicated analysis actually in the courts, where it's like this multi-factor test where do you have public events, and at those events, can anybody come, or do they have to be invited by a member? And so whether the club is truly private is this kind of detailed analysis. Typically, if there's a membership requirement and they're selective in who's a member, so it's not just I pay money and I can become a member. If there's other requirements, and then the only way you can attend events or services is by invitation of a member, those types of institutions are typically considered private clubs. But if a country club has a golf tournament that anybody can pay to play in, they're going to have to comply.
Wasn't something I actually thought about. And then when you said it, I thought, well, what if it's a private club, but you're going to a wedding? So it's like you're expecting accommodations, like regular accommodations, and then that's not what you find. And that's a upsetting thing to find at the same time.
Oh, yeah. Yeah, and that we get cases like that sometimes where there's nothing we can do, because when you do that multi-factor test, yeah, it's a private club and not covered.
Somebody also was asking about sidewalks being carefully maintained and repaired. Is that also something that is covered, so that, especially if you're on a scooter or you have a walker?
Yes, it's covered. They're very hard problems to resolve. We have so this idea of a program under the ADA, a city system of sidewalks is considered a program or service, and so sidewalks are covered. But it can be hard to get the city to comply with the ADA. We have many situations, for example, where a sidewalk leading to a bus stop is not accessible. So a person in a wheelchair must go around and take a dangerous route to the bus stop. And we do advocacy directly to the city to fix it, but it can take a lot of perseverance to get them to fix it, because you're just dealing with a large bureaucracy. There was a recent case that I think is illustrative against the city of New York, because they have the walk signals that are audible and which are necessary for people with visual impairments to effectively cross the street, but they only have them at like 2 to 3% of intersections in New York. And so people with visual impairments sued the city and said, well, the pedestrian program in New York or system of sidewalks is inaccessible to people with visual impairments because they can't cross 97% of streets. And they actually prevailed in that case. And the judge ordered the city to take action to remedy that and make all cross sections have an audible mechanism to it. So yeah, sidewalks and pedestrian issues can be covered.
Somebody asked me, explain, I did suggest that this person probably needs to speak with an attorney, because I'm sure there's a lot, but he was saying he was just let go from his company. Performance was excellent, but they claimed that the job was no longer needed. Is that something that it's just sort of like, yes, that can happen? Because you know?
Yeah, at least from a disability rights perspective, there might be other labor laws that provide protection, but if it wasn't because of the person's disability or in retaliation for a request for an accommodation or something like that, then there would be no problem under the ADA at least.
I had a couple of my young onset group, and both of them were in a service industry. One was in maintenance, one actually did carpentry. And what they would always say is that it wasn't that they couldn't perform their job, but they were always worried if somebody saw the tremor. Like one gentleman would say, he's like, you know, when I've got the soldering torch in my hand, he's like,
Yeah.
I admit that it would scare somebody if they saw me. But he's like, once I, you know, I'm doing what I'm supposed to do and everything is fine. What would happen? Like, so he was so terrified somebody would catch him, because what he was basically saying is that he's like, I don't need accommodation. I can do my job, but I think it would scare somebody if they saw what basically happens before I actually, like, as I'm firing up the
Yeah.
torch and I'm holding the torch. But then he's like, and same the other gentleman, he's like, as soon as the saw goes on, my hands are not tremoring. But if you saw me beforehand, you'd be like, you're about to use an electric saw. That's scary,
Yeah.
you know.
Well, that, you know, that conjures up kind of the classic type of disability discrimination where people have preconceived notions of what individuals with disabilities can and can't do. And so if someone sees that individual tremoring and then just assumes that that individual cannot use the saw or complete the job duties and takes adverse action against them, you know, that would be an adverse action based on bias or prejudice that's not supported by the facts. So that would be like a more classic type of disability discrimination claim, as opposed to denial of reasonable accommodation. And that can be hard to prove. You know, those are our hardest types of cases, because for people with disabilities, the argument that they've encountered most is safety. This person can't be on this job because they're unsafe. This child can't be in a regular school setting because of safety. And so that can be a powerful explanation by employers. And so what that individual would be tasked with doing is trying to show, no, this isn't a safety issue. This is just, you don't understand my disability, and there's a need for education. And we do that. That's an important role of the P&A, is educating employers. Okay, this is what Parkinson's is and its effects. It doesn't prevent somebody from doing this. This like reminds me, you know, a lot of people in the autism community think that the movie Rain Man was like one of the most damaging movies to that community, because now everyone thinks autism is how Dustin Hoffman presented in Rain Man. And that leads to prejudices and biases that make assumptions about other people with autism. And that's problematic. And so this kind of reminds me of that similar thing.
He also kind of, I guess, thought along the same way I did about, he asked about, what about a municipal men's golf club? Would they have to?
Yeah, they'd have to comply, especially municipal, because then you're covered under Title II. If it's city run, state run, they got to comply.
You kind of had mentioned that somebody, a business could say that's an undue hardship. Could you give, I mean, because it's like, we can all think of an obvious one. Like if you said, I need you to tear this out and do this for me, what would be a more basic that they might argue is an undue hardship if somebody were to ask for example?
Or an employer?
Yeah. Like if they're like kind of pushing back and they say that's an undue hardship.
Yeah, say you work at a small business, so like a business like 20 employees, I think that's around where the ADA covers, and the income or the profits that it generates is not significant. And in order for you to complete the job duties, you need some kind of assistive technology software that costs $20,000 a year. That might be an undue hardship. It's a very fact-specific analysis that's looking at the resources of the business and the business operations. And so for some smaller businesses, the threshold might be lower. Whereas if you worked for Microsoft or BP, then that type of assistive technology software might not be an undue hardship.
I did wonder about, because you obviously covered universities, what if you're not necessarily a student, but you're on campus, for example, for a presentation or a seminar? Like, for example, we have done that where, like, we've gotten a room at University of South Florida, for example. What happened? Is it the assumption is that they're already set up, or like, honestly, it never occurred to me to get the PowerPoints beforehand. Is that something that would normally be coordinated beforehand? How does that work? Because I realized I wasn't actually prepared for that.
Yeah, if you are similar to being a student, if you're a guest on campus and you need an accommodation to participate in some kind of class or a presentation, then yeah, you need to request it beforehand. If you show up and request it then, it might be deemed unreasonable because there's not enough time to grant that request. Yeah, always plan ahead. That's the safest, and make requests ahead of time, both in colleges, universities, and if in other kind of public places that you might go to, where in a request ahead of time could work.
Yes. As always, Roger pointed out, you never want to be confrontational. So make it
Yeah.
nice when you're
Yeah.
asking. Can you tell me a little bit about the intake process? If, we reach out, we call, what exactly, what does this process look like?
So we have an intake team, and all PNAs have an intake team where you'll be assigned an intake specialist, and they will ask you questions about your problem and also demographic information because of our federal grants. And they're trying to issue spot and see, okay, what are the potential violations that you're presenting or issues that you have? And then what they'll do after they collect the information and sometimes documents from you, they'll send the case on to a lawyer or director who will look at it and assess, okay, are these issues within our goals and priorities such that we can address them under our federal grants? And typically we can, if there is a meritorious argument that there's a violation. The main reason why we will deny assistance is if there is just no basis, or it's an issue that's not disability related. But so the intake process, we try to make streamlined, where you're just interacting with one person and you're having a couple phone calls with them and then maybe providing them documents.
What happens? I just got a direct message. If the employer states that the employee can't do the duties because he's not always able to write in, but their accommodation is to just limit his duties, that's how they're accommodating him. So then what happens is that then he's never going to get promoted or receive a pay raise because they're like, well, you're not doing everything. Are they doing their due diligence, or they're basically not accommodating in a way? Because it's sort of like they're like, well, we're just going to take this away from you, and that's our accommodation. But then as a result, it's like, well, because you're not doing it, we're not going to give you a raise. We're not going to give you a promotion. What happens in that sort of a situation?
That's interesting, because they're basically rewriting the job. Because if the essential job functions, there's 10 of them, and then the employer is saying, well, you don't have to do these 3 things, that's a new job. And that's how I would think of it. So they're basically putting you in a different job instead of accommodating you in your current job so that you can fulfill your current job's duties. And so I'd probably advocate to say, well, so that I can have equal opportunities for advancement and continue in my position as the position I applied for and agreed to, I'd like to explore accommodations that allow me to do those job duties instead of losing those job duties. Because that's kind of an adverse action. Less responsibilities is typically associated with a type of demotion. And so that might be one way of looking at that.
Common, because you talked about it, and I was like, because I know that's one of the biggest things with Parkinson's is the fatigue around 3 p.m. where people have said they're like, Eden, it's like I've hit a wall. It's not like I'm tired. It's like I can't get up tired. is that common, the accommodation you mentioned, like, are most employee, because I was like, wow, that would be really to start work at 6 a.m. And I understand that's not obviously based in a customer facing role per se,
Yeah,
but is that something that you do think is common, that people will make that adjustment, or you're like, well, it's nice when it happens, but it doesn't happen a lot? Because I know that's something that would mean a lot to a lot of our folks.
I think it's common in professional jobs, but not shift jobs. Shift jobs, there's a lot of fights over that, or disputes about that. But I have seen a number of cases where the employer was fine with that type of modification when it's not a shift job, and it doesn't mean rearranging someone else's schedule. That's when you get into issues. If you have a type of job where if you need to start earlier, another person's schedule needs to get rearranged.
When you were saying that, I was like, that is huge, because I'm just thinking of so many of my young onset patients that
Yeah.
have had to rearrange, or like, I've had a couple and they say that they're like, what I kind of just do is I take a nap and
Yeah.
then I get back to it. But they're like, I need that nap or else like it's just
Well,
not
that
gonna
can
work.
be, you can say not just starting earlier, but I'm going to start at same time, 9 to 12, but I'm going to take a 2-hour nap, 12 to 2, and then I'll finish at 6. Like, that's another modified work schedule that could work.
This was incredible. Thank you so much for all your time, for giving us your time today, Kevin. This was, I mean, I personally learned so much.
All right, good.
We did put a couple of links in the chat, including for the Job Accommodation Network. So I do, as always, encourage you to save your chat. If your chat is open and you click on the bottom 3 dots, it'll say more, and you can click and save your chat. Kevin has graciously agreed to provide the slides for us, so that will be available tomorrow on our website. And of course, we thank you for joining us. We have a tradition here at PMD Alliance. We have our wave of gratitude. Kevin, thank you so much for all of this today. This was wonderful.
Yeah, thanks for having me.